Hi, I'm Abigail Taylor, founding and managing attorney of Ovron Law Group. Before I started my firm, I worked as a trademark examining attorney at the United States Patent and Trademark Office, where I reviewed hundreds of trademark applications. Today, I'm sharing 5 common mistakes that I saw way too often so that you can avoid them. Number 1, entity mismatch. What this means is simply listing the incorrect owner of the trademark application. And I know that sounds really simple, but it was definitely one of the more common mistakes. So for example, let's say the name of your business is ABC Coffee LLC, and that's what you're using as the applicant for this trademark application. But then when it says to indicate the type of owner, you put individual instead of saying that it's an LLC. It really happens very often. Let's use another example. Let's say you have ABC Coffee Corporation as the applicant, and then for the owner type, I've seen people list LLC. So it doesn't match. It's like corporation to LLC, LLC to individual, and like partnership to corporation. Point is the type of applicant. So whether you're filing as the applicant as an individual, when it asks you for the type, you need to say that it's an individual. If the applicant is an LLC, you need to say that the type is an LLC. Very straightforward, but very common mistake. These mismatches raise red flags, and it can lead to, as simple as it sounds, can lead to a refusal or a delay. Always double check your entity information to make sure that the owner name and the entity type match exactly. Number 2, missing a translation. If your trademark includes any foreign word, you must provide a translation or transliteration. This is not optional. So for example, maybe your brand name is La Bella, right? You need to provide the translation saying that it means the beautiful. Failing to do this can hold up your application. My pro tip for this is, even if you made up a word, do a light search to see if it means anything in a different language, because maybe it does and you just didn't know. Or maybe there's a word you've heard or you heard somewhere. Look up if it means anything. And if it does mean something, provide the translation or the transliteration for the USPTO office. Number 3, the mark doesn't match the specimen. So this is the classic one. You file, I'll give an example. Let's say you file a word mark for Squirrels, Coffee, and Nuts. Let's go with that. Your specimen, which is what you submit as proof that you're using the mark. Let's say your specimen has the name Squirrels, Coffee. It doesn't match, because on one hand we have Squirrels, Coffee, and Nuts, and then on the specimen you have Squirrels, Coffee. It's not the same thing. And this could lead to a refusal or a delay. The small differences matter. If your mark says one thing, but then your specimen shows something else, the USPTO is not going to approve it. So my tip here is make sure that your specimen matches your mark exactly. If your mark includes and nuts, your specimen should too. Number 4, submitting the wrong specimen. I often saw applicants submit specimens that didn't actually show how the mark was used for their particular goods and services that they applied for. So let's use an example. I love examples. So let's use the same coffee mark that we talked about earlier. So let's say your mark that you're applying for, your trademark that you're applying for, is Squirrel, Coffee, and Nuts. And then the goods that you're offering, you're selling under this mark I almost said squirrel mugs, is coffee mugs, right? That's what you're applying for. But then you provide a specimen. Let's say you use your website as the specimen. And on your website, there is no way to purchase mugs. There is no way to purchase coffee mugs. Maybe you have like coasters, or I can't think of anything else right now. Maybe you have other goods on that website, but you don't have anything for your coffee mugs. Okay, so then we have a problem, because that means that you have not showed proof that you're using the mark that you applied for in connection with the goods and services that you listed in your application. My pro tip here is, when you submit your specimen, reference your application to see what goods and or services that you listed, and make sure that your specimen shows that you offer those services and or goods under the mark you applied for. Number 5, forgetting disclaimers. So if your mark includes descriptive or generic terms, you will need to disclaim them. And what do I mean by descriptive or generic terms? Let's use the same example, squirrel nuts at squirrel coffee. and nuts. At this point, somebody should just start this business. But yes, let's use that example. Let's say the goods that you're selling under Scroll Coffee and Nuts. You're selling coffee and maybe some peanuts, cashews, that realm, right? So you would need to disclaim the words coffee and nuts because it simply describes what you sell. And so you need a disclaimer for those. Without the disclaimer, your application could be delayed or refused until it's corrected. So just a quick recap, what did we learn today? The 5 common mistakes are entity mismatch, missing a translation, the mark doesn't match the specimen, submitting the wrong specimen, and forgetting disclaimers. I hope this video was helpful. If you want to avoid these mistakes, or maybe you've already received an office action and you just need some help, then feel free to visit ovronlaw.com and book your consultation, because at Ovron Law Group, we help protect what you create.